Okay, so hi everyone. I think that we'll start the webinar now. We have around 53 participants on the call today, so that's really great. But welcome to today's HR event, which is focusing on new UK HR legislation and responsibility changes for 2022. My name is Jacqui Brown. You may be familiar with me already. I'm the HR manager at Goodwille. At Goodwille, we help overseas companies enter, grow and scale in the UK. We do this with 5 different departments: corporate governance, finance, HR, payroll and virtual office. So without further ado, if I can introduce my team, Rob and Annie, if you want to pop your cameras on. There we go. So Rob, Winchester and Anni Glesaaen are both HR advisors at Goodwille. I'm sure that, again, many of you on the call today will be familiar with all 3 of us from one time to another. As a team, we support the full employee life cycle from start to end. And we can also assist with global mobility matters involving secondments and sponsorships as well. If you can just flick to the next slide, please, Nancy. So here we can see an overview of what we'll discuss today. So we've got the statutory changes which are coming in April, which I'm sure you're all waiting with bated breath to hear about. And then we've got the end to COVID regulations as we know it, the changes to visa and right to work matters, which are pretty slight at the moment, the employment bill, post-termination restrictions, and some case law, which is shaping legislation that we thought you might want to hear about. So we've got lots to get through. So let's crack on and I'll hand over to Annie.
Thank you. Okay, so if I start off with the statutory changes, which is kicking in now from April. So in terms of the minimal national wage, it's an increase there. As you know, these are all tiered. So it goes from age, from then 23 and over, it's now gone up to 950. So we have an increase of 6.6%. And then it goes down to like the 21, 22-year-old, that is 918, 18 to 20-year-olds, 683, 17 years old, they are 462. And of course, the apprentice rate also needs to be included, which is 481. We have also an increase in family-friendly leave pay that covers maternity, paternity, shared parental leave, or pay, adoption and bereavement pay. And that has now gone up to 156.66 per week. That comes in from, you can see different dates, but that's from the 3rd of April. We have then increased to statutory sick pay, which then goes up to 99.35. That comes from the 6th. We have increased to statutory redundancy payment. The max pay will now be up to 17,130. So that's maximum amount of weeks pay is 571. So that's an increase of £27 from last year. We have also an increase to national insurance contribution that comes in from July, not April, but July, and the increase will be 1.25%. This increase will actually be spent on the NHS, health and social care in the UK. The employees' national insurance contribution will then be on 13.25% and the employees will be 15.05. There is exemptions if you have a certain pay over £967 a week, then it's an additional percentage of 3.25, but just bear that in mind. Then, of course, as we all know, the inflation, it's the highest recorded levels in 1992. The inflation seems to be maybe on an average of 5.75 this year. Of course, this depends on the publication you read, but also research done by CIPD shows that an average salary increase among the public as well as the private would be around 3%. So there's already a gap in that. Okay. Thank you.
Sorry, I'll unmute yourself. Can we have the next slide, please, Nancy? Oh, Annie, you're muted.
Sorry, we should have known all this technical bit now after 2 years on pandemic, but here we go. Yeah, the public holiday, we will all be happy that we have an extra day to celebrate the Queen's Jubilee coming in at the beginning of June. So the early May bank holiday has now been moved till Thursday the 2nd, and then we have another day on Friday the 3rd of June. So that will be a long weekend. Thank you.
Okay, so I've got the lovely task of talking about COVID again, which we're all tired of hearing that word. I note that the slide does say the end to COVID, and I'm pretty sure that we wish that was all the case, but sadly not. But the UK government is telling us that COVID has ended, so that's good. As you may all be aware from reading various publications, the remaining restrictions as we know it in the UK ended on 1st of April. We were promised a further publication on 1st of April from the UK government on its Living with COVID series. But as of today, 5th of April at 10:39, that has not materialized. So sadly, we can't give you all the juicy bits of what they're going to tell us of how we can, live COVID free. But we will wait with bated breath to see what that's going to say. Ultimately, there is a concern, of course, for many businesses about returning to the workplace and health and safety, of course. So many businesses have had a return to the workplace already in some form for a while now. But of course, there has always been a requirement for those who test positive to work from home if they can, and self-isolate for varying periods of time. And that has been the instruction from the UK government for those with a positive test. What we also do know is that from 1st of April, the free COVID-19 testing for the general public ended, although it was announced on the 29th of March by the Social Care Secretary that the government will continue to provide tests for NHS workers and those living or working in high-risk settings. So if you require your employees to test prior to entering the workplace, then as a company, you will be required to pay for private testing. So the government guidance is that with vaccines and treatments, COVID is to be managed like any other respiratory illness, and that people with COVID symptoms are to exercise personal responsibility, just like if they have flu. And as mentioned, while we are aware of the new testing facilities from the UK government, in that for most people there isn't going to be anything free, we do not have the new guidance which was promised from 1st of April regarding how employers can make changes in the workplace in line with the government's Living with COVID plan, which it is expected that they will advise that people who are displaying symptoms of a respiratory infection, including COVID-19, who have a high temperature, who feel unwell, all of the usual symptoms that we've heard about, that they should try to stay at home for 5 days and to avoid contact with other people until they feel well enough to resume normal activities and that they no longer have a high temperature. So this advice will also apply to children and young people attending school, college or childcare. And of course, that may impact employees with caring responsibilities. So just bear that in mind. And we expect that also they will advise anyone with a positive COVID-19 test result to stay at home for 5 days and avoid contact with other people. So not just if they're symptomatic, but if they do have a positive test. And we must remember that from 24th of March, statutory sick pay rules also resumed to those of the pre-pandemic. So there's no special payment now or treatment for COVID-related sickness. So any statutory sick pay will now not be payable from day 1 like it was with COVID illness. It will now be payable from day 4. Also, we normally always look to the Health and Safety Executive to tell us what we should be doing in terms of our risk assessments in the workplace. From the 1st of April, the HSE also no longer requires businesses to consider COVID-19 in their risk assessments or to have any specific measures in place for COVID-19. And there is, of course, still a requirement to protect those who come into contact with the virus due to their work activity. Now, this means, HSE mean by this, people who are working in laboratories or in a health and social care setting. They do not mean where one employee catches a respiratory infection from one another, like say if they work in retail, or if there is a member of the general public who was infected an employee. So this is not what the HSE mean by that advice. They are purely talking about health and social care people, those who are working with noxious diseases within laboratory setting. So again, I feel like I've banged on about this a lot, but we're still waiting for the guidance from the UK government. But what guidance there is to come from that quarter, we are just making assumptions at the moment from what we've heard so far. there will be obviously a requirement, as there always is, to provide sufficient ventilation as per general health and safety laws. So that's something that you absolutely need to do. But of course, this then lays open the concern for employees that have a concern that they may be working alongside a colleague who may have COVID, now that there's no longer a need to self-isolate in sectors outside of health and social care. So employees may not just be concerned about themselves, they may have a family member who's vulnerable, and then there could also be workers who are immunosuppressed or clinically vulnerable. So we just need to bear those individuals in mind as well. Just because UK government and HSE are not saying that it's a legal requirement to put any mechanisms in place, you can still, as an employer, have the freedom to implement your own policies and measures to mitigate COVID-19 spreading. So we just need to think it is a balancing exercise for employers to ensure the safety of their employees while living with COVID. So maybe the recommendations would be to review any existing policies and risk assessments that you have in place, look at what you had included over the pandemic for COVID-19, which of course you should have had COVID-19 risk assessments in place for the last 2 years now. So what can be dropped, what can be retained, how are you communicating to your workforce about how to manage risk in the workplace? Although face coverings and masks are no longer a legal requirement, maybe it would be appropriate as an employer to ask employees to wear PPE where it's not able to implement social distancing. And then maybe they don't need to wear PPE when they're in their own office environment where they're not near anyone else, as an example. Hand washing and sanitizing is just good practice anyway, and maybe you just continue down that route. And maybe you want to purchase some testing kits as well. So if you do have employees who are coming to work who are displaying symptoms, you can provide a test, and maybe that can be part of your policy, that someone has to then display a negative test to continue working. If we think about vaccine status as well, that's obviously been quite a hot topic. Of course, that has been mandated in health and social care from April. There was a recent case where a tribunal deemed that an employee was fairly dismissed for refusal to be vaccinated, but this was in a nursing home setting. So just bear that in mind. It's not a green light for you as an employer to dismiss employees who refuse the vaccine. And there has been a lot of discussion around individuals' human rights and if they would be infringing on someone's human rights if the vaccine was enforced in a workplace setting. We also need to remember as well that there's been a lot of conversation, and Annie will be touching on this later, actually talking about belief systems, but whether an anti-vaxxer could be considered a belief when we think about protected characteristics and discrimination. There's nothing that's gone through the courts yet, but I fully anticipate that we will be seeing something, given that there's been such heated arguments about this. So in summary, I don't want to take too much of the other guys' time, but if you do have pushback from employees who do not want to come to work due to the change in legislation because they feel unsafe, look at what you as an employer can implement in your workplace as a company, as a policy on how you're protecting your employees. Look at your workplace risk assessments. Are they updated and robust? Are you looking at sanitization, PPE? Have you purchased test kits? What are the clauses in your employee contracts regarding the place of work? Can you allow 100% home working? Is that going to work for your business? And does the employee have a medical issue, or do they live with somebody else who does? So it's really important to know more about why you're getting pushback in the first place. The bottom line is it could be possible to pursue your disciplinary policy if they do refuse to come to work, but it should be treated with caution. There's a lot of red flags along the way. So yeah, if you are facing any issues, then please do reach out, and we'd be happy to try and help you. I'll hand off to Rob now.
Thanks, Jacqui. So I'm going to touch on some flexible working conversation, and particularly paying attention to what we call displaced workers, or people that have, over the course of the pandemic, based themselves overseas. For lots of employers, particularly those in the SME market, who've been able to embrace hybrid or remote working in the lead up to the pandemic, might be more familiar with the changes that hybrid or remote working brings. As people start to return to the office and to kind of figure this new way of working, it's important that we give due consideration to the policies that we have and to how we manage the change, so that people feel empowered and that they can stay in the arrangements that they with, both on the employer and the employee side. So first and foremost, for an employer, it's really important that we consider what kind of policies we have in place already. Do you have a flexible work policy? Do you have a remote working policy? How's that managed and who's responsible for it? If you don't have policies on those topics, and of course Goodwille are here to support and to help you with that, but you really need to think about the level of detail that you're putting into that policy and how it's managed. Now, if employees have worked overseas during the pandemic, then you really need to consider the impact that that has to their contract of employment, and whether or not you as an employer need to kind of ratify those changes, or if they would revert back to the ordinary contractual position. There can be disagreements between employees and employers, which you really need to consider, particularly in the wave of what we hear in HR as being called the Great Resignation. You know, it's becoming more difficult to retain talent. So it's really important in a very candidate-driven job market that we're able to have honest and open conversations about new working arrangements, which have come up as part of the pandemic. We need to acknowledge that there may not be an automatic right to work from home or to work from abroad. But again, if competitors are offering this, then employers really need to think about how they can retain any kind of competitive advantage. Now, for many, the opportunity to work from home throughout the pandemic has involved being based overseas. Now, this is where we start talking about displaced workers. Now, people may do this to wait out lockdowns or to be closer to loved ones throughout the pandemic. Now, what we really need to be careful of and to consider are what we call tax residency rules. Now, there are a number of different arrangements, and rules do change from country to country, but where there is a double tax treaty in place, employees may become liable to pay tax both in the UK and in the country that they're working from. Now, there are, as I said, different rules, but one particular rule, for example, is that where an employee is based for 182 midnights in another country that their employment's not based in, then they may incur double tax. So it's a very complex area of law, and you should get in touch with Goodwille and certainly with local support kind of on the ground for countries where employees are based sort of temporarily. So if you haven't already done that, then you need to really consider it and get in touch with us, and we can kind of talk you through some of the implications. This may involve looking at payrolls domestically in those countries, or looking at things like permanent establishments. Now, HMRC have released some guidance on the subject, but while things return to, or as things return to the new normal, the consensus is that employees need to get to grips with their own tax arrangements, and particularly where temporary displacements are becoming permanent features of employment. So as these things become more fixed, the onus is really transferring back to the employees to manage their own tax liability. But you need to be really cautious. Again, Goodwille can offer some support and some guidance in this area. One thing that's really vital is that you're making sure that employees have the right to work, obviously based when they're based in the UK, but if they're working from other parts of the world, you'll need to make sure that visas and other sort of immigration rules have been complied with. So it's always worth making sure that you understand your obligations under right to work checks for these workers who are working overseas. I'll hand back to Jacqui to talk a little bit more about visas and right to work.
Okay, so I'm not going to talk about existing right to work or visas that we have in the UK, because they are forever changing, bearing in mind that this is a webinar to talk about changes that we have coming this year. Ultimately, the UK government recognised that the visa system that we had in place wasn't necessarily working for a lot of businesses, particularly those who are new to the UK, can't necessarily say that the changes that they've made are particularly groundbreaking, but what they've tried to do is consolidate some of the existing visas which are in place, particularly for the ICT route, so intercompany transfer. Not going to go into too much detail here, but if you want to speak to us after this webinar, then please feel free. On the 15th of March, the government announced details of the new global business mobility visa route. So that is expected to open next week on the 11th of April. This new route will have 5 different pathways for overseas firms to establish a UK footprint or to transfer staff to the UK. So again, this is more emphasis on transferring employees who already work for a parent company rather than necessarily hiring new talent to the group, for which they'd still be using the skilled worker route. But there are going to be 5 new visa categories. So senior or specialist worker to meet specific business needs. There's going to be the opportunity for graduate trainees who are part of a formalized training program. Secondment workers, so this is something that we get involved with a lot. There's going to be a specialist visa for them, which, to be fair, used to be part of the ICT route anyway. Service supplier, so that is those who are working in the UK in line with UK trade agreements. And then also UK expansion worker, and this is to replace the old representative of an overseas business visa, where companies want to establish a UK presence. So again, a mix of recognition that that companies need to sponsor individuals where they do have a UK presence and where they don't. For those with sponsorship or for those who have come to the UK via the settlement route, it is a requirement now for employers to check with relevant non-UK citizens about their right to work status, as has always been the case anyway, but this will be using an online portal. So the employee issues a share code and then the employer can check their UK right to work status online, and that's where that's stored. So there's no longer BRP cards. And landlords will also need to follow the same procedure for right to rent checks. So if you are bringing someone to the UK, just bear that in mind, that there's no sort of cutting corners. Generally, they will need to actually show their ability to be in the UK via their landlord as well. Also, just a final note that there was a reprieve from the UK government due to the pandemic for UK employers not needing to use original documents to conduct right to work checks. So we're talking about passports, physical passports and so on. And that also ended as of the 1st of April. So you have a requirement to see the original documentation. That's all for me. I'll pass on to Annie.
And then, as we know, we have a lot of companies and places around the world who's looking at different flexible ways of working already. But here in the UK, there is now a 6-month pilot program where they're recruiting companies to study the impact of shorter working hours and then look at the business's productivity, the well-being of the workers, as well as the impact on the environment and gender equality. This is a pilot program, which they now will follow a model called 100-80-100, where workers receive 100% of their pay for 80% of their time in return for committing to maintain their productivity they previously had at 100% level. So this is a research program which is now done by Cambridge and Oxford University, as well as Boston College, together with groups as 4-Day Week Global, 4-Day Week UK campaign, and the UK think tank. They are aiming to recruit 30 companies to take part in this, but so far it's a big success. So they are looking at increasing into 50 companies, and this is supposed to start in June. Countries like Iceland have already done this with an overwhelming success and have then been in the forefront. There is another country who's done this very well, which is Japan in 2019 already, where they gave all the workers free on Friday with paid leave. And it actually boosted their productivity with 40% in addition to environmental benefits, which was electricity consumption fell by 23% and staff used 59% less printed paper. So that's great. There is, of course, a lot of positive stuff in regards to this, which I just mentioned. The green benefits reduce the carbon footprint, the wellness for the employees, where you then get actually a 3-day weekend where you can use much more time on family, friends, and hobbies, whatever suits you. It's also maybe something a lot of employees would like to look at in terms of good PR. Maybe they're aiming to be the employer of choice. And also, like we mentioned briefly, the diversity, that you actually share the responsibility in terms of caring responsibilities, and it will be much more equal between the genders. There is, of course, some negative which have to be considered, and that is the risk of burnout. If you are taking on too many hours, if it is more than your normal hours in a day. It could be difficult for the employers to monitor. Said that, over the last 2 years with the pandemic, of course, there has been a lot done towards that. So maybe not as difficult as first estimated. It could be very disruptive. It could be a resentment by other workers that maybe some feels that some is pulling their weight more than others. It could be a risk of conflict of interest. So let's say that you're working 4 days and on the 5th day, you might actually take on work for a different employer, if that is the case. And that might not be something your main employer would like to be encouraging. It could also be an issue in regards to the working time. Will you actually be able to comply with the working time regulations if you take on extra work? How can that be monitored? Will you have enough break times as you should be? And also, it could be a risk of sex discrimination. Let's say that if you don't apply this to also part-time workers, that they also have reduced hours according to also still receive full pay. All these things needs to be taken into account. But yeah, it's going to be interesting to see when they get this pilot program off the ground and see the report in 6 months' time. So we're talking at the end of this year. Thank you.
Thanks, Annie. So I'm just going to touch very quickly on the employment bill. So this was a piece of legislation that was originally proposed in 2019. Obviously, throughout the pandemic, it suffered numerous delays, but we are expecting it to come into force in 2022. There are a number of areas that employees need to be aware of, and I'm just going to take you on a whistle-stop tour through some of the big ones. So first and foremost, it's envisaged that there will be an introduction to the right to employees to request flexible working as a day one right. So currently it's 26 weeks worth of service that somebody needs to have before they can request the right to work flexibly. But we are anticipating this to drop down to being a day one right. Now, I thought it would be sensible just to run through the 8 potentially fair reasons that an employer could reject a flexible work request. But if you have questions, or if somebody has submitted a flexible working request and you want to discuss this with Annie, Jacqui, or myself, then please do let us know. But potentially the reasons that you could reject a request are the extra costs involved for the business, work not being able to be reorganized among existing staff, people not being able to be recruited to do the work. Flexible working may affect the quality or the performance of the business not being able to meet customer demand, a lack of work to do during the proposed working times, or the business planning changes to the existing workforce. So just very quickly, I thought I'd sort of rattle through those. But if you do have questions on that, then do let us know, because it can be a bit of a difficult conversation to have. And we're of course here to kind of guide you through that. Now, the process will largely be the same. So employees wanting to submit a flexible working request under the new rules will need to go through the same process. Any requests for flexible working will need to be made in writing. There is a form, but usually they tend to sort of just come in via an email. And the business needs to give those due consideration. And you really need to think about those potentially fair reasons for rejecting or accepting a flexible working requests. There is a mandated time period for employers to go back to such requests. and that's 3 months. But potentially, you may look to do that much sooner. And if you have a flexible working policy in place already, then you are, of course, sort of bound to go back to employees within whatever time periods you have stipulated there. So if you don't have a policy and you want one, let us know. If you're having some issues dealing with flexible working requests, then again, let us know and we can help you with that. Now I'm going to come on to talk about something that the government have been talking about for a long time, and that's the Good Work agenda. Now, this is an attempt to mirror some EU legislation that is termed the EU's Transparent and Predictable Working Conditions Directive. It's a bit of a mouthful. Now, this has been put in place really to sort of combat some of the negative implications of what we call the gig economy, and a number of the issues that are addressed by the proposed legislation are really aiming to redress some of the issues that are felt by particularly those who are working on variable hours contracts, or zero hour contracts, you might have heard them called. So one of the big changes that we expect to see is the right for individuals under these sort of 0 hour contracts to request what's being called a stable and predictable contract after 26 weeks of service. So there is still going to be a time period before somebody can request that. But the suspected eventual impact of that is that individuals won't have to suffer through the unpredictability of a 0 hour arrangement on an ongoing basis. So just trying to bring some balance back to the relationship there. There will also, it's likely that there'll be new rights for reasonable notice of working hours. So no longer will employers be able to phone workers and ask them to come into work, with a couple of hours notice. The aim here, obviously, to stop companies habitually requesting workers to attend work at very short notice. There will be some practical benefits to that. But I think a longer term benefit will be to enable workers to better plan their working time so that they can have some of that stability in that employment relationship, but also in any other employment relationships that they have at the same time. And there's also been some discussion about addressing short notice shift cancellation, because obviously where workers under these arrangements are disadvantaged by having work cancelled at the last minute, that will have a serious impact to the bottom line, to their monthly income. So generally the employer should give at least 7 days notice before changing unpredictable shift patterns, which is currently considered to be reasonable, but it's likely that as part of some of the changes that will be tightened up. So just if you are employing or working with people who are on variable hours contracts, it's worth just making sure that you're aware of the changes that are coming here. Some of the other notable things to be on the lookout for are leave for carers. So the EU will enact the EU Work-Life Balance Directive by August 2020, certain elements of which the UK government have promised to match. One of these is a new baseline right for carers and working parents. So under the UK's plans, working carers will be able to take up to 5 days leave each year to help them with their ongoing caring responsibilities. At the time of speaking, as of today's date, it looks as though this time will be unpaid. So just something to be aware of. And again, we anticipate that this will be a bit of a flagship policy under the employment bill. So you can expect to see that sort of in the headlines, I suspect, when this comes out. There's also some new leave for neonatal care. So the government have promised to implement new rights for 12 weeks unpaid leave for parents whose children spend time in neonatal care units. This is in addition to changes to parental bereavement leave, which has been offered to employees who have lost children during childbirth. So this will be an extension to some of the other rights that are already in place, but we expect the full details of these to come as part of the new bill. There will be some changes to maternity and redundancy rights. So part of the plans under this bill include upping the level of protection for returning mothers who face redundancy. Currently, these individuals who are returning from maternity leave have a higher level of protection from being made redundant anyway, but there are plans to further increase the level of protection. And it's likely that this will include such individuals having a priority for alternative employment in the event that they are selected for redundancy. So just making it easier to retain those individuals in the business. Again, we expect full details of that to be forthcoming. One thing which has been a hot topic for the last couple of years now is sexual harassment and the Me Too movement. And I'm going to talk about non-disclosure agreements in a second, but the government have made pledges to increase the duty on employers to prevent sexual harassment in the workplace. Now, it's likely that this means that employers will need to take a higher level of responsibility in the event that any of their employees or workers are harassed by, this new legislation is now looking sort of up and down the supply chain. So looking at both customers, suppliers, and anybody else whom their employees have sort of day-to-day contact with. So really, really important that you have robust policies and procedures in place that your line managers are familiar with and that you're comfortable with, so that you're meeting these new sort of enhanced obligations that this bill will put into place. And this is in addition to some updated guidance that we expect to be coming from the Equality and Human Rights Commission, who've released a new code of practice. So we can sort of provide some more guidance on that if you're interested, or if you have any questions about that in the future. There are various sort of training webinars that Anni, Jacqui, and myself deliver through Goodwille on a range of topics, including harassment and bullying. So if that's of interest, then please do let us know. Now, NDAs or non-disclosure agreements, gagging orders, you may have heard them called, they're also being looked at as part of the changes to legislation. So you may have heard them called confidentiality agreements, and you might have seen them or built them into employment contracts or into settlement agreements if you have employees who are exiting a business. But there are discussions at a high level within government about how these have been used, whether or not they're being sort of open to exploitation and suppressing things which shouldn't be suppressed, and how they should be treated moving forward. A lot of this has come out in the light of the Me Too campaign. So one thing that we're expecting to see is that new legislation this year will tighten up the form of these agreements, and it's unlikely that they'll be able to be sort of a blanket confidentiality agreement. And we envisage that gagging orders or non-disclosure agreements will be treated in a similar way to settlement agreements. That being said, before employees are asked to sign them as part of any exit, employers will likely be obliged to pay for their employees to have some legal representation look over such agreements to make sure that they are meeting new laws. So just something to have an awareness of. If you're dealing with settlement agreements or exiting employees, that can obviously be quite a contentious subject anyway. But if you want some assistance on that, then do of course come to us and let us know. I'm going to hand back over to Jacqui to talk about post-termination restrictions.
Thanks, Rob. So yeah, as Rob said, there's a whole load of things coming with the employment bill whenever that actually comes to fruition. As Rob mentions, we've been talking about this for a couple of years now. But there is further government consultation on proposed changes to post-termination restrictions, or you may know them as non-compete clauses. So that consultation closed on the 26th of February last year. And the key points on the consultation was whether changes should be made to non-compete clauses and whether they will be enforceable only when the employer pays part of the employee's salary during a non-compete period. An alternative proposal was whether to make post-termination and non-compete clauses in employment contracts unenforceable altogether. So again, this has been something that's been discussed for a while, and I know with some people that are on this call, we've often had conversations around what typically happens in PTRs in the home country's contracts versus how we handle them today. Typically speaking, today in our post-termination clauses, we do not have the ability to be able to contractually enforce that the employee pays X amount of money in exchange to get out of their PTRs. Typically speaking, that just doesn't work for the UK, but it may change. So it isn't definitely going to happen. Some legal contacts that we know don't think it's likely for 2022, but it's worth bearing in mind. And as always, as Rob's highlighted, Goodwille are happy to assist you with any PTR questions that you have. Our current advice, based on the existing status of PTRs, is that if you, PTRs are generally always more enforceable if you are paying the employee for circa 50% of the restricted period. So as an example, if you have a 6-month post-termination restriction in your contracts, then it's probably going to be more enforceable if the employee breaches their PTRs, if you've paid them maybe 3 months notice period, normally under a garden leave arrangement, because you're paying them for 50% of the time. And you're not then sort of preventing the person from making a living for an unreasonable duration of time. But we'll see what happens, whether the UK government do pass this new proposal, what direction they decide to go down, and whether they will strip PTRs out of contracts altogether. But as they are, it's business as usual. So do please speak to us if you do have any questions on that. I'll hand back off to Annie.
I'll then have a little look at things we might need to bear in mind, and that could be about the case law shaping legislation and policies. None of this has passed the bill yet, so that is to come. Well, we'll have to wait and see. But we're going to talk about gender critical views and belief protection. Religion and belief is a protected characteristic in accordance with the Section 10 of the Equality Act 2010, but are gender critical views capable of amounting to philosophical belief? And it can be, but of course that depends on the circumstances. When a tribunal are going to establish whether a belief is capable of protection, they need to look at 5 criteria, and these criteria are called the Granger criteria, which could be a belief must be genuinely held. It must be a belief, not an opinion or viewpoint on the present state of information available. It must be a belief as to weighty or substantial aspect of human life and behavior. It must attain a certain level of seriousness, coercion, and importance. And the last one is it must be worthy of respect in a democratic society, not be incompatible with human dignity, and not conflict with the fundamental rights of others. Quite hefty. So if I'm just going to show to one case in regards to this Granger criteria, we had a claimant. This is a case about a claimant who was working as a consultant following with the respondent, and the claimant held a very gender critical belief, which included that the belief that biological sex is unable to be changed and not to be conflated with gender identity. The claimant engaged in debates online and about her beliefs, and her colleagues found her comments very offensive. Her consultancy was terminated by the respondent, and she alleged that they amounted to discrimination as her views. Her consultancy was with the respondent was not renewed, and she alleged the reason for that this amounted to discrimination as her views amount to a philosophical belief. It went to tribunal, and they found against her due to number 5 on the Granger criteria, where it must be a worthy of respect in democratic society, not to be incompatible with human dignity, and not conflict with fundamental rights or others. She appealed and was successful. So yes, I'll be very, very careful when we're looking into this, that gender critical views, are they capable of amounting to philosophical belief? And in this case, it was. I'm just going to also touch on very quickly menopause, which seems to be very high on the agenda for employers, and it should be at the moment to look at the well-being perspective. Symptoms which can affect attendance as well as performance, productivity, and confidence, among others. Menopause is not a specific protected characteristic, at least not yet, but you can still make a claim through age discrimination, disability discrimination, and sex discrimination. Just want to touch on a case which happened in regards to the menopause side, and where we have an individual who was taking medication for menopause-related cystitis. She dissolved the medication in water at home and took it to work. She poured herself a jug of water and left it. And when she came back, it was gone. She was having full panic. And one of the or the symptom for her was a severe brain fog. So she was like, okay, what has happened? And not sure where she had left it. What had happened was that a male colleague had taken the glass of water and offered it to somebody else. And when then she came back, she had said to the people and said, I think I might have actually my cystitis medication in it. When that was disclosed, it was a big hoo-ha, and it went into an enormous investigation into health and safety grounds of why the medication was left unattended in the office. The employer dismissed her, and she brought a claim of unfair dismissal and disability discrimination. She claimed that from something arising from her menopause, being a disability, the brain fog around her medication, and what she had done, you discriminate against something around her disability. And she won. She won in regards to disability discrimination, won also towards unfair dismissal, in addition to compensation of 20 grand. She then later could actually have, if she had remembered at the time, she could have remembered that when she dissolved her tablet in water, it would actually have turned pink. But she at that moment could not remember because of her brain fog and other symptoms to her menopause. So it all comes down to the point that wasn't what the point was that it wasn't discussed anything around her disability. If they had discussed that, looked into the case from her side as well, it might have looked at a different scenario, but sadly it wasn't. This is definitely something to bear in mind. We can see that there is a growing numbers of employees being taken to court because of menopause, and in 2021 we had 10 cases in the first 6 months. So the advice is probably just to say that please don't take immediate action, seek advice and take the case a little bit step by step. Thank you.
Thanks, Annie. Just to be clear as well, Goodwille didn't have 10 cases at tribunal. Just want to make that clear. But yeah, Annie's talking about general cases that have gone to UK tribunals and things that are ultimately, we just need to look at cases that are ending up in court because they are shaping how we treat things. So when we don't have a set criteria that, okay, somebody's menopausal, they fit under this level of discrimination, we just need to understand about the specific scenario and what the risk areas could be, where obviously Annie's explained that contentious case there, and it was a knee-jerk reaction from the employer, which is definitely what we don't want you to do. So do please speak to any of the team. So I think we did have some questions, and I think we've had one that's come in the chat box as well. That's probably quite a quick one to answer. Tim Burridge, you've asked whether you need to see original documentation to prove right to work from the start of this month. Okay, sorry, you've said that you need to see original documentation from the start of this month. Is it sufficient to see a copy of the documentation, as in passport, prior to issuing a contract, and then on day one, the original document as a follow-up check? I would suggest that you actually put an offer out and request to see like the original documentation at that point before you issue the contract of employment. So yeah, generally I would say you want to see the original before they start, but if all fails, then you need to see it on day one of employment at the very latest so that you can rectify. Okay, thanks Tim. Okay, so other questions that we have, I know we've got approximately 8 minutes before the end of the session. What is the impact of remote working on the location of the employee from an employer's point of view? I mean, I guess, Rob, you've answered some of this during the session, but I don't know if you want to quickly recap. You're on mute, Rob.
Yes, I can recap. So I suppose the big take home away on this is it's a difficult area. So take some specific advice first. So where somebody is based overseas, you need to be really, really careful that you're not incurring double tax liability. Now, lots of the documentation that's coming from HMRC is suggesting that the onus is transferring back onto the employee to manage their own tax affairs. But obviously you want to be supportive as an employer, and you want to make sure that you're doing everything that you can to support them if they are sort of displaced and are working overseas. Now, if you're looking at bringing them back to the home country, i.e. to the UK, then you need to make sure that you're operating within the realms of your own flexible working policy. You need to make sure that you're checking what's already been agreed with that individual. I would suggest that most people have sort of come to some kind of permanent type arrangement, given that we've been in this scenario for a couple of years now. But if there are sort of specific case-to-case examples that you want to discuss, then by all means get in touch, and we can advise or put you in touch with people who can give very, very specific sort of international tax advice, and we can talk you through sort of standard working practices for bringing people back to the office.
Okay, and we've had a question from Rika, extra public holiday 2nd to 5th of June, those couple of days that we've got. The Queen's Jubilee is only in 2022 and not going forward. Yes, that's correct. Just this 1 year only. Okay. What changes should employers be making with the rising cost in the UK? I mean, Annie, you covered that section, didn't you, when you talked about inflation?
Yeah, and it's really, really hard to answer that, because I guess that will depend from employer to employer, financial situation as such on. But it's very much a recruitment challenge at the moment, and very, very high pressure on starting salaries. So that is something to bear in mind, of course, with the increase in living cost to be considered. Not that that is something you have to do as an employer, but just bear in mind that that might be something which is then pushing up the starting salaries, since the living cost is, of course, in terms of council tax, water bills, food, electricity, as we all know about. The other thing I would just say is that maybe employers need to be having a much more holistic approach in terms of how they want to look into talent recruitment or attain talent. So it's really, really hard to give one answer, but it's many factors within each employers.
I think perhaps one thing just to add is that it becomes more important to look at benchmarking when you're putting adverts together or when you are recruiting. So just making sure that what you're offering has you've got some good comparators in the market. And again, you know, that's something that Goodwille can assist with. So just reach out to us if you're kind of unsure how to approach sort of figures in the UK market, and we can give some guidance there.
Yeah. There was a question that came in about the end of the COVID-19 rules and whether employers still need to keep potential contact records for a certain time. And I believe that's linked to if you have someone that's come to the workplace with COVID-19 or has developed symptoms. I mean, the HSE rules and the government, well, the government may come up with something, who knows, we haven't got their guidance yet, but it doesn't look likely that will happen. But going back to what I was saying in the main session, it's up to you as an employer to develop your own policies on that. So maybe it will make your employees feel more comfortable if you do actually request that people do let you know if they have COVID, if you are going to be implementing a certain period of time where they need to stay at home or stay away from the workplace, if they're symptomatic or they have a positive test, then you can roll that up as part of your own company policy to try and keep your workforce as safe as possible. So yeah, there's not a legal requirement as far as we are aware from HSE, but you can always develop that as a company policy. I think we've got a couple of minutes left. Does the employer need to ask the employee's passport if they have provided settled status document? Yes, because that is an original document of their identity, and generally that passport will go hand in hand with the settled status. And normally you will get someone's evidence of their date of birth from that document anyway, which you need to actually use the share code to obtain the settled status document online. So that will be a yes for that one. Okay, and advice for requests to work from home when a request may be difficult to accommodate or not practical for the role, any pitfalls to avoid. I think that kind of goes half and half with your section on flexible working, Rob, and also my section on COVID. It's quite a tricky one to answer really, but Rob, as you had said, a working from home request is a flexible working request. And so you would still go through the normal flexible working request procedure where Rob had outlined I think it's the 8 reasons why you can decline someone's request. So you would need to go through a formal process for that. If the working from home request is because of COVID, then there's obviously a whole other area to think about there, and whether the individual has a medical reason why they're asking and so on. So whoever did ask that question, if you do feel free to contact us with a bit more meat on the bones around that, and we'll do our best to try and help. Okay, I think we've come to the end of our session with about 30 seconds to spare. Well done, team. We've actually finished on time for once. But thank you to everyone for attending, and yeah, any further questions, then do feel free to route them through myself or Annie or Rob. Thanks everyone.